Hello everyone, my name is Kirti and I am an assistant professor in ITM. Today I am going to discuss the concept of void agreement and contingent contract, and this is part 8 in business law. Void agreement. The Indian Contract Act 1872 under section 2G defines a void agreement as an agreement that is not enforceable by law. Such an agreement is void ab initio and it does not give any rise to it any legal consequences. It would be an agreement or contract which has no legal value. Legally, a void agreement means a contract or agreement is no longer enforceable, or we can say that it has no legal existence in the eyes of law. Now, the void agreement has been divided into two parts. Number one is never valid and second one is valid ones. Now, never valid agreement means which is not valid from the initial stage, or we can say it is a void ab initio agreement. Valid one means at an initial stage it would be valid, but later on due to some circumstances it become invalid. Now, agreement never valid agreements. An agreement that was void from the beginning is said to be void ab initio. In order to be a valid, the agreement must contain all the elements listed in the Indian Contract Act 1872 section 10, which we already discussed in the previous video. Ab initio agreement violated the Indian Contract Act from the beginning and are not valid. Example of such an agreement like cannot be executed, such as street vendor selling the Brooklyn Bridge to a tourist. Now, Brooklyn Bridge is one of the famous bridges in some country. How a street vendor can sell the bridge to a tourist? That is not possible. It can't be executed. Second is were made without consideration. As you know that without consideration there is no contract, so it is illegal. Having unlawful consideration or object, include a party that is a minor, intoxicated and legally insane at the time of signing. Next is uncertain agreements. Uncertain agreement means whose terms and conditions are vague. Next is expressly given under the act. If it is defined under the act that it is invalid, right? So that is the agreement which is never valid agreement and it is void ab initio from its starting stage. Essentially, these agreements has no legal effects in the eyes of law that never existed. Agreement which are valid ones. A void contract is a contract or agreement that ceases to have a legal effect. Unlike a void ab initio, these contracts did at one point contain the elements listed in the Indian Contract Act and therefore at least initially are considered valid legal agreements binding to both parties. A few ways a contract could become legally void are: number one is the contract become impossible to fulfill due to external circumstances. Might be some war has to be existed. If previously it would be valid agreement, but when war has been existed, how can you make a contract with the alien enemy? That is not possible. Now, law changed since the initial agreement and the agreement now require breaking the law. Right now, when the agreement has been made, the law defines that you can make the agreement, but later on the law has been changes, so you can't make the agreement. Next is fulfilling the contract will result in something unlawful. Next is the contract was contingent of circumstances that cannot come to pass. Now, contingent contract means there is some condition which need to be fulfilled while making the contract. If this condition has not to be fulfilled, the contract become void. Next is one party failed to disclose key information or provided inaccurate information. Technically speaking, a fulfilled contract is also void contract as the parties involved are no longer bound by the contract and therefore it has no legal effect. It means these are the agreement which initially has some legal effects, but later on due to some circumstances the contract become invalid. Next is void ab initio agreement. Number one is agreement is restraint of marriage. Section 26. Every individual enjoy the freedom to marry and the law regards marriage and marital status as the fundamental right of every individual. So, according to section 20G, every agreement is restraint of the marriage of any person other than a minor is void. This restraint may be absolute or partial, but the agreement is void, and therefore an agreement not to marry at all or a certain person or a certain class of person for a fixed period is void, right? Now, for example, A agrees that if B pays him rupees 50,000, he will not marry. Such an agreement is a void agreement. The famous case law of Rao Rani and Gulab Rao, there is two persons X and Y, two co-widows, agreed that if any of them remarried, she would forfeit her right to share in the deceased husband property. Held, the agreement was enforceable since it was no restraint on the either of widows to remarry. Next is agreement is restraint of trade. Now, every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent it is void according to section 27. This liberty is granted by the article 19 of the constitution as the fundamental right. So, public policy requires that every man shall be at liberty to work for himself and shall not be at liberty to deprive himself of the fruits of his labour, skill or talent by any contract that he enters into, right. However, there are certain exceptions to this rule. Number one is a sale of goodwill. So, according to section 27, the seller of the goodwill of a business can be restrained from carrying on a similar business within a specified local limits so long as the buyer or any person deriving title of the goodwill from him carries on a business like thereon, provided the restraint is reasonable in the point of time and space. Second is partnership agreement. Now, similarly, if an outgoing partner can enter into a restraint of a trade agreement with the partnership firm, also a contract between parties not to carry out any competing business during the continuation of a partnership is also valid contract. Next is trade combination. So, where the primary objective of trade combination is to regulate business, not to restrain it, the agreement is valid. Therefore, an agreement between traders or manufacturers not to sell their goods below a certain price, to pool output or profit and divide in this is an agreed ratio, does not amount to an agreement, is restraint of trade and is perfectly valid. Next is service agreement. So, an agreement of service between the employer and employee by which an employee bind himself during the terms of the agreement not to take up service with any other employee is not regarded as restraint of lawful profession, is perfectly valid. Next is sole selling agreement. So, an agreement between the manufacturer and a sole selling agent or distributor, whereby the manufacturer agree to sell all his output to the sole selling agent or distributor, may be restrained from the goods of other manufacturer. For example, XYZ Pharmaceutical Limited, a medicine manufacturer company, let us suppose XYZ Pharmaceutical Limited, a medicine manufacturer company, appoints ABC Pharmaceutical Distributor Limited as sole selling agent and agrees with them that sole selling agent that shall not sell the medicine manufactured by other companies. Such restraint is valid. Next is agreement is restraint of legal proceeding. So, according to section 28, an agreement by which a party is restricted absolutely from enforcing his legal right arising under a contract by the usual legal proceeding in the ordinary tribunals, or an agreement which limits the time within which the contract rights may be enforced, right. So, these are the agreement restraint of legal proceedings. Section 28 of the Indian Contract Act 1872 was amended by the Indian Contract Act 1986, which came into force on January 8, 1997. The amendment of section 20 has brought about the change that all clauses which reduce the normal period of limitation would be void to that extent. It now prohibits clauses which seek to extinguish the right of any party thereto or discharge any party thereto from any liability under in respect of any contract on the expiry of a specified period, so as to restrict any party from enforcing his right. Now, however, there are certain exceptions in it. Number one is, if the agreement stated any dispute between the parties will be entered to arbitration and the amount awarded in such arbitration will be final, will be a valid contract. And second is, also if the parties agree that any dispute between them in the present or the future will be referred to arbitration, then such an agreement is also valid, but such a contract has to be in writing. Next is agreement void through uncertainty. So, uncertainty agreement are those agreements whose terms and conditions are vague, ambiguous or uncertain, right. So, law cannot enforce such agreement. An agreement to enter into an agreement in future is void due to uncertainty. Similarly, agreement in which the prices to be paid are based on luck or uncertain event are also void for uncertainty. An example has been given that X agrees to purchase fruit from Y. If there is no way to determine which type of fruit was agreed upon or intended, then the agreement is void. If a party Y in the above agreement is a grapefruit farmer, then there is a clear indication of what type of fruit was intended and X would be still liable to make the purchase. Now, wagering agreement. So, according to section 30 of the Indian Contract, an agreement to wager is a void agreement. The basis of a wager is that agreement depends on the happening or non-happening of a certain event. Here, each side would either win or lose money depending on the outcome of such an event. The essential of wagering agreement are as follows: if all the elements are met, then the agreement will be void, must contain a promise to pay money or money worth, and is conditional on the happening or non-happening of a certain event. The event must be uncertain, neither party can have any control over it. must be a common intention to bet all the time of making the agreement. Parties should have no other interest other than the stake of the bet, and the following agreement are not considered as wagering agreement like chit fund, commercial transaction, transaction of the share market, athletic competition, competition involving skill, insurance contracts. Next is impossible agreement. An agreement to do an act impossible in itself is void. Contract to do an act which after the contract is made become impossible or by reason of some extent which the promisor could not prevent unlawful become void when the act become impossible or unlawful. So, we can say that an agreement to do an act impossible in itself is void. For example, A agrees B to discover treasure by magic. How B can discover the treasure by magic? It's not possible. The agreement is void. Next is A and B contract to marry each other. Before the time fixed for the marriage, A goes mad. The contract become void. Next is contingent contract, very important. A contract may be either absolute or contingent. An absolute contract is one in which the party must perform their reciprocal promises in all events. A contract is said to be contingent or conditional in which the promisor binds himself to perform the contract only on the happening or non-happening of some uncertain event. For example, A agreed to be rupees 5 lakh for the construction of a building. This is an absolute contract. And second example is A agreed to pay B for rupees 5 lakh for the construction of a building provided it is approved by C and architecture. This is a contingent contract because there is some condition include that if C approves that the contract become valid. So, contingent contract means when the certain condition is included in particular contract, right. Section 31 of the Contract Act defines a contingent contract as follows. A contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Essential of a contingent contract. The performance of contingent contract depends upon the happening or non-happening of some future event. The event must be uncertain. If an event is bound to take place, it will not be a contingent contract, but it is an absolute contract. So, if the event is certain, so it is not a contingent contract, it is an absolute contract. The uncertain event must be collateral incidental to the contract. Rules regarding the performance of contingent contract. Section 32 to section 36 of the Indian Contract Act contains rules regarding contingent contract. These are explained below. Number 1, contract contingent on the happening of an event. Section 32. So, when a contract to do or not to do anything is contingent upon the happening of a future uncertain event, it is enforceable only when such event has happened, and this section further provides that if the event become impossible, such contract become void. Example, A agreed to sell a horse to B at a specified price. If C, to whom the horse has been offered, refuses to buy him, the contract can be enforced only if C refuses to buy him. Now, contract dependent on the non-happening of an event. Section 33. Where a contract to do or not to do anything is contingent upon the non-happening of a future uncertain event, it can be enforced when the happening of that event become impossible and not before. For example, A agreed to pay B a sum of money if a certain ship does not return. This ship is sunk. The contract can be enforced when the ship sinks, but if the ship returns safely, the contract becomes void. Now, third is contract contingent on the future conduct of a living person. Section 34. So, when a contract is contingent upon how a person will act at a specified time, the event shall be considered to become impossible when such person does anything which is rendered impossible. For example, A agreed to pay a sum of money if B marries C. Now, C marries D. This marriage of B, C must now be considered impossible, although it is possible then D may die and then afterwards C will marry to D. Number 4 is contract contingent on the happening of an event with a fixed time. Section 35. They can be enforced if such event happens within that fixed time or it becomes impossible to happen before the expiry of fixed period, the contract becomes void. For example, A promises to pay a sum of money if a ship returns within a year. The contract may be enforced if the ship returns within the year and becomes void if the ship is burnt within the year, does not return within the year. Next is a contract contingent on the non-happening of an event within a fixed time. Section 35. They can be enforced if such event does not happen within a fixed time or before the expiry of the fixed period, if it becomes certain that such event will not happen. For example, A promises to pay B a sum of money if a certain ship does not return within a year. Now, the contract may be enforced if the ship does not return within a year or it's burnt within a year. So, next is agreement contingent on the happening of an impossible event. Section 36. These agreements are void whether the fact of impossibility is known or unknown to the parties at the time of making of a contract. For example, A agrees to pay B rupees 1000 if B will marry C, that is A daughter. C was dead at the time of agreement. The agreement is void. So I hope everything has been clear to you. So basically the contingent contract is basically to do or not to do something if some event collateral such contract does or does not happen. The parties are interested in happening or non happening of the event, right. So I think everything has to be clear to you. So that's all for today. Thank you so much.